Welcome to Inside Medical Malpractice. This subject fascinates everyone everywhere because it affects everyone everywhere. My name is Chris Rokosh. I'm a registered nurse, legal consultant and educator, and the president of Connect Medical Legal Experts. Medical malpractice affects patients, families, nurses, doctors, midwives, healthcare institutions, the associations that define medical standards, lawyers, and the general public. Each month, we'll be looking at malpractice issues from different perspectives, featuring honest, candid, insightful interviews by people and professionals with a wealth of information to share. Thanks for spending time with me today. Now let's dive into this fascinating subject. I'm here today with Richard Halpern, a lawyer from Thomson Rogers in Toronto. In fact, a medical malpractice lawyer and a very experienced one. And we're talking about medical malpractice, which is of interest to so many of us in healthcare and the general public and in the legal realm. In the first two sessions, we talked about some of the legal principles around medical malpractice. And in the second one, we talked specifically about when a patient or plaintiff walks into a lawyer's office, how do they determine whether or not that they have a viable medical malpractice lawsuit on their hands? So we're at the point now where the lawyer has made a decision to take on the case. And what I'd like to talk about today, and I think everyone will be interested in, is what happens next. What is the process of a lawsuit? How does it get started? How does it proceed? How long does it take? What are the steps from point A to the resolution? And I'll just turn it over to you, Richard, to take us through that from beginning to end.
Thanks, Chris. When we last spoke, we talked about obtaining expert opinions and getting an expert to support the fact the case has merit. Based on that opinion, then we proceeded with a lawsuit. The way we start a lawsuit is by issuing a claim in the court, whatever province we're in. That starts the lawsuit running. And there are certain stages that happen between the time that you start the lawsuit and the time that a case might reach trial. Some very crucial things happening. That period of time from the start of the lawsuit until you get to trial can be 4 or 5 or 6 years, depending on the case. So it's a long process, particularly in a significant case. The next significant step in a lawsuit after starting the claim is something called examinations for discovery. In Alberta, I think they call it questioning. This is an opportunity for the lawyers on one side of the case to question the parties on the other side of the case under oath about the matters in issue in the case.
Can I just stop you right there for a second? Again, for the doctors and nurses and healthcare professionals that might be listening in, up until this point, until you issue this statement of claim or notice or whatever it's called in what province, would the doctor and nurse potentially or her about to be involved in the case have any awareness or have any idea that a lawsuit is about to be launched?
Generally, they'll know because before we ever start a lawsuit, we request their records. So when they get a lawyer's letter saying send the records, that's notice that there's going to be, or there may be, a claim. So I think they do know. But the official notice to the doctor, the nurse in the hospital will be when this claim is issued. The claim is a document that sets out the facts of the case, and that claim is actually served physically on the nurse, the doctor, and the hospital. They get a copy of that claim, and then they will retain lawyers if they haven't already done so. They probably already have advice from lawyers before that happens.
What does that claim read like? Like what is the allegations going to be?
So the claim is intended to be factual. It starts by making a demand for money. The demand for money is really never a true reflection of the value of the case. I think people need to understand that because when the claim is issued, we really don't know the value of the case. We have to wait. And then it is a factual recitation of what happened. It's not evidence, and it's clear that a claim cannot be evidence, it's only facts. So it recites the facts, and after reciting the facts, it will make certain allegations of negligence against the parties that are being sued, doctor, nurses, hospital. And we will particularize in that claim the nature of the criticism that we have of the parties that we've sued.
And what does that criticism look like? The nurse or doctor has failed to do what?
Right. So it's either the nurse or doctor has done something that they should not have done or failed to do something that they should have done, the former being an act, the latter being an omission. So we will specifically say, let's take, as we have in previous discussions, the birth trauma case as an example. We would specifically say the doctor, the nurse failed to appreciate this baby was under stress. The doctor, the nurse should have turned off oxytocin because there was excessive uterine activity. The doctor should have delivered this baby sooner. The doctor and nurse should have appreciated that the baby was under stress from impaired oxygenation and so on and so forth. So we get very specific about what was happening clinically during the period in issue, and we make very specific allegations against the doctor and the nurse. And the allegations that we make are very important because the later questioning we do is based on the allegations we make in the pleading.
And are there allegations too? I know this is a question from a lot of nurses I've talked to. When a lawsuit is commenced and they are named as a defendant, there's concern that they are personally being sued and will be responsible for the damages. The allegations, I understand, are also against the hospital or the employer. Can you talk a little bit about that liability and that connection?
Sure. So the allegations against nurses and doctors are personal and specific to them. They are the frontline workers. They are the ones that provided the care or failed to provide the care that we say should have been provided. And nurses and doctors will be directly responsible for the failure to provide adequate care. In the case of nurses as employees of the hospital becomes vicariously liable for the negligence of the nurses. What that means is that the hospital will defend the nurses, that if the nurses become liable to the injured patient for any damages, that the hospital will step in or the hospital's insurance will step in and provide the compensation to the injured patient that is awarded as against the nurse. So the nurse doesn't have to dig into his or her own pocket to pay the damages suffered by the patient. The doctors, on the other hand, are defended by a different organization, the Canadian Medical Protective Association, the CMPA, and the CMPA covers the cost of the defense, so the legal cost to defend the doctor. In the event that there is an award of damages made against the doctor, the CMPA again will step in and pay that judgment, provided that the negligence is committed in connection with the practice of medicine.
So the nurse and doctor personally, in a medical malpractice civil suit, don't pay the money.
That's right.
Just to confirm. I think that's a fear that a lot of people have, and they don't really understand. And in response to the statement of claim or notice, what do the doctors and nurses do? I know this is a moment of terror in many healthcare professionals' lives. It's like your worst dream coming true. So how do they defend themselves in that situation?
The CMPA for the doctors, or the insurer, or the health insurance reciprocal for hospitals, will meet with the doctor or the nurse. Now, I'm not a defense lawyer, so I have not been privy to these meetings, but presumably they meet with the doctor and with the nurse, and they get their story about what happened. And based on the facts as told to their lawyer by the nurse or the doctor, the lawyers for the nurse or the doctor will file a statement of defense, which will admit anything in the claim by the patient that they feel ought to be admitted, and then deny anything else that they take issue with.
What's an example of what they'll admit and what they'll deny?
Well, in my experience, they admit very little. Generally speaking, you can expect no admissions except for non-controversial facts.
So the factual stuff. This patient was admitted to this hospital on this date,
Exactly.
etc.
Right. Mm-hmm. They'll admit things that are not of controversy, but anything that has a bearing on the loss will be denied, sometimes in a pro forma way, sometimes specifically, but it's going to be denied, and then it's left to the parties then to fight that out later.
It's a very adversarial process.
No doubt.
No doubt, no doubt. And different from healthcare. So I think that's why many healthcare professionals find this such a frightening process, because healthcare innately just isn't adversarial, or typically not in a day. So the statement of claim's been filed, the statement of defense in response, and then you talked about examinations or questioning.
Yes. So this is the opportunity and probably the most crucial step in any case, particularly for the patient. Acting for the patient, it is my opportunity to examine the nurses and the doctors separately, each individually. So I'll spend a day with a nurse, and I'll spend a day with a doctor, and I'll spend a day with hospital administration. And I get to ask them questions under oath about what happened in the case. And the focus inevitably is on the records and the care that was provided to the patient. I essentially get to test the defendants, the doctor, the nurses, on what they did and why they did it. I want to know what they did and why they did it, and I will focus on what I understand to be the errors, the acts or omissions that should not have taken place. What doctors and nurses need to understand is that I walk into that questioning, that examination for discovery, fully prepared. I try to learn their area of expertise as well as they know it. So it's an enormous, I think that doctors and nurses should assume, if they're going to protect their own interests, that the lawyer on the plaintiff side has prepared to the nth degree, which I do in every case. I like to say that for every hour that I end up questioning a witness, I spend a full day in preparation. And if you are a defendant in one of these cases and you keep that in mind, you know the level of interrogation that you're going to get. I think it's important to acknowledge the mistakes that you may have made and then be prepared to fight the issues where you haven't made a mistake. So a good plaintiff's lawyer, a good lawyer on behalf of the patient, will have studied all the medicine, all of the guidelines, received advice from the experts used in the case to advise the lawyer, be completely familiar with the records, and understand the facts like the back of his hand or her hand. That is the way lawyers prepare to properly represent patients. A nurse or a doctor should expect, in one of my cases, to be grilled quite extensively on the care that they provide, because it's my belief that I make or break my case when I question the defendants.
How typical is it that the nurse or doctor has a memory of the details of the case?
It's not uncommon to have only a vague memory or no memory of the events, but the records are there for the witness to refresh his or her memory, and usually that is sufficient. The problem that doctors and nurses run into, of course, and we've talked about records before, is where the records are vague or there are things missing from the records that will impair the ability of the expert to, or the defendant expert, to recall exactly what happened. And sometimes they revert to the usual practice. This is what I would have done in this clinical scenario. That's often a dangerous thing for nurses and doctors, because what they would have done may be entirely inconsistent with the outcome in the case. That's the problem that they face. So they have to be very careful about how they deliver their evidence based on usual practice, given the circumstances and the actual outcome in the case. It often doesn't work.
And how do you handle the situation where, I've read hundreds of medical records, and it's not uncommon that parts of them are illegible, and which makes it not only difficult to recreate the events of the case, but I would imagine, difficult to defend or go forward on a case. How do you deal with illegible writing, and how do you question a doctor or a nurse about their writing when no one can read it?
This underscores the importance of communication amongst the healthcare team. If writing is illegible, it might as well not have been written. I had a case against an anesthetist once where, when I was examining him for discovery, there were probably 6 or 7 entries in the chart by him that were crucial to the case. Not only could the nurses and the other members of the team not read the record, but the witness himself was unable to read his own handwriting. Mm-hmm. Well, that's like not making a record at all. That's a joke. That should never happen. That's careless. That's negligent. Say what you want. And if you can't read your own handwriting, then essentially you have communicated nothing to the team. You make an order about the patient's management of care, and you can't yourself read it. You're guaranteed that the nurse can't read it. It's a recipe for disaster, and it's a recipe for errors to occur. It's unacceptable practice. Today, in this day and age where we have electronic records, it's less common, although I think what we're finding with electronic records that is more common is that doctors are neglecting to enter anything contemporaneously.
Yeah, that's a whole nother subject that we could spend an hour talking about because it's challenging on all sides. You know, the electronic medical records are challenging. So let's carry on. So you're at the point where you've questioned the doctor and the nurse. We've gone through the interrogation or discovery, the questioning, whatever you want to call it. And what do you hope or expect comes out of that conversation?
So we need to understand that when we examine nurses and doctors, this is done under oath. It's not done in a courtroom. It's done in a boardroom with a reporter who records all of the questions and all of the answers. And while there isn't a judge present, all of the questions and all of the answers are transcribed. So we have those questions and those answers, and it's under oath.
And they could show up in court. Is that true?
So the use that we make of the transcript, what I try to achieve when I examine the defendant doctors or the defendant nurses, is I'm trying to, number one, understand the nature of their defense of my case. But really my objective is to get them to say things that are going to help my case. I want them to make admissions that will help me prove my case. And I get them 99% of the time. And
so give me an example. How would you ask a question of a doctor or nurse that would get them to admit, in a way, something that would help your case?
A clear example, let's take a late diagnosis cancer case. The doctor gets the hematology report back that the patient's hemoglobin is low. Nothing's done about it. There's no follow-up. Nothing happens. A year later, somebody does something about it. I would ask the doctor, you have the results. What system did you have in place in your office to read the results, to ensure that the patient is informed about the results, and the results are followed up on? Well, of course, it didn't happen here. So whatever system they have was obviously inadequate to the task. And that's a simple one. But there's many scenarios where the outcome really dictates how we deal with that scenario. There's lots of scenarios where that applies.
It's a tough one. It's a tough one from the healthcare perspective, I think. I'm just imagining my own self being on the hot seat. And it would be a tough situation because so many things that you do in healthcare are done routinely or without question or without any understanding of the outcome.
You were asking me, though, I didn't really address your question directly, which was, what use do we make of this transcript?
Yes.
When we have it? And it's this. At trial, I can do one of two things with a transcript. Number one is, if I get the doctor to make admissions or the nurse to make admissions at the examination for discovery, I can actually read the transcript, the questions and the answers that I rely on, into the record at trial, and that will be evidence as against the party who made those admissions. So that's one thing I can do. The other thing I can do is I can go to trial and I could ask, say, the nurse a question, and she'll give me an answer. If I asked the nurse the very same question at the examination for discovery, but at trial she gave me an answer that differed from the examination for discovery answer, then at trial I would confront her with the transcript. I would say, you were under oath on both occasions, that you have now given contradictory answers. I might not go quite so far as to say, on which occasion were you lying? But obviously that's problematic. So we use...
That's the hot seat.
That's the hot seat. And we use the transcript to essentially challenge the credibility of the experts at trial. They've been posed the same question on two occasions, both under oath, and given different answers.
And how does the information that you obtain, receive, elicit during the questioning, how often does it affect the direction of where that case will go? Will you make a decision to walk or drop or settle or go forward?
Right. So remember, before I get to the examination for discovery, I invariably will have medical support for my case. I will believe that my case has some merit. After I complete the questioning of the defendants, I then will reassess the merit of the case. Is there something that the nurse or the doctor said during questioning that causes me to reconsider whether my case is a good one or a bad one? Is there something that was said by the doctor or the nurse that might affect my expert opinion? I may have to send the transcript to my expert and say, is there anything in the testimony of the nurse and doctor that alters your opinion about the merit of my case? So I routinely will do that with my experts. I find, generally speaking, that my case improves after examinations for discovery. It doesn't get worse. It generally improves. And when I send the transcript to my experts will more often than not say, not only am I reinforced in my original opinion, but actually there's additional factual information that you uncovered at discovery that makes me even more forceful in my opinion. So it's a very, very important step. If I learn something at questioning that shakes the foundation of my case, if I feel that the nurses and the doctors are so credible as to be likely to be believed by a judge or jury at trial, I will reconsider whether to carry on with the case. And I may drop the case at that point if I feel that the defense is insurmountable.
What's an example of something that's come up during discovery that caused you to drop a case or change direction?
I've actually never dropped a case after discovery because of something a witness said. That's not the reason why I've dropped it. There would have to be a change in circumstances. And I think the reason for that is that before I get to discovery, I've really already done my due diligence. I have the facts from the records. I've consulted with highly qualified experts. Those experts have provided opinions to me that encourage my client to proceed with a lawsuit. It would have to be some incredible revelation at discovery that could undo all the work that I've done before I get there. It'd be quite incredible. And it hasn't happened. I'm not saying it can't happen, but it hasn't happened to me yet.
Okay, so we're at the point where you've questioned or discovered the parties involved, the doctors and nurses and everyone else. What happens next?
Right. After examinations for discovery, I then will deliver to the defense all of my expert opinions, both on standard of care, causation, and then I will do my damages workup. So what is the extent of my client's financial losses? Does my client need care? Is my client going to be able to work? Is there treatment in the future that my client is going to need? How is this going to translate into economic losses for my client? And I will deliver those as quickly as I can to the other side immediately after discovery, even though I'm not really required to do so under our rules until much later. But I try to give the other side the earliest possible notice of what my claim is all about, both on the liability side and on the damages side.
And can I just stop you right there for a second? Because what you just said, when you're determining economic loss, is that how the decision is made on the amount of damages claimed in a lawsuit? Can you discuss that briefly?
Sure. There are three elements I like to describe it as three elements to the damages. Number one is pain and suffering. Pain and suffering in Canada, though, is capped. It's limited. So it's not the big part of the case. The other part of a claim is loss of income or impairment of income earning capacity. And that's a mathematical calculation. You make a certain amount of money a year, you can't go back to work. We get economists or actuaries to calculate that. The big ticket item that drives most medical malpractice cases are economic losses that relate to health needs, care needs, housing needs, transportation, therapy, that kind of stuff. If you have somebody who's profoundly disabled, they need attendant care. Depending on the expertise of the attendant that's needed, it may be a personal support worker. It could be an RN. A personal support worker at $26 or $27 an hour, 24 hours a day is a lot of money. An RN at $55 or $58 an hour, 24 hours a day is even more money. So if the patient is going to live a long time, you can see that annual care needs can get upwards of $150,000 or $200,000 a year in very severe cases, even more in some cases, depending on where you live. And if the person has a reasonably long life expectancy, we're talking about large sums of money, multi-millions of dollars.
I see. So that's how the 10 plus 13, $15 million cases come to be. The actual hard costs of caring for that patient in addition to the pain and suffering and loss of income.
Exactly. The costs of care is the variable that really drives up the cost of litigation. So in these catastrophic cases where people need a lot of care, that is how we get into the multi-millions, not pain and suffering, and often not income loss unless it's a major wage earner.
All right, so we're at the point now where you're working up damages. You've had the questioning. You've got the damages workup. What happens after that?
After I've delivered my reports on both liability and damage to the other side, they have an opportunity to respond. They will retain their own experts to look at standard of care. They will retain their own experts to look at causation. They will retain their own experts to look at damages and have their damages expert actually visit with my client in order to form an independent opinion of the losses. And then essentially we have a battle of the experts. Inevitably, the defense experts are going to disagree with my experts. It happens in every case. And what we have to do is fight that out. We have to look at where they challenge our case, and we have to respond to that. If there are legitimate challenges to how we presented our case, we have to consider those. If we feel that the challenges to our case aren't legitimate, we have to respond to those as well. And the way we respond is we get our experts to respond to those things. We may even engage more experts. But at some point, both sides have drawn a line in the sand in terms of where the case is all about. And after that, we then explore the various methods we have to see if we can bring the matter to resolution. And those methods are, you can meet directly with the other side and negotiate a settlement, talk about the case. That probably doesn't happen that often. Sometimes we proceed to what's called a mediation, where we get an independent mediator to meet with the parties and encourage the parties to resolve some or all of their differences. Another way is, certainly in Ontario, we have pretrial conferences, which are meetings where a judge will meet with the parties, and the judge will express her or his opinion on how they think the matter will play out in the event that the case goes to trial. And if none of those methods work to resolve the case, then ultimately you may proceed to trial.
So going back to those three potential outcomes, how often does the settlement discussion, I think you mentioned already that is not that always that effective. How often is mediation effective in sorting out the issues in a trial or coming to an agreement?
Mediation has turned out to be a bit of a drawn-out process in the medical malpractice field, I find. Some cases will settle at mediation. In some cases, mediation will prompt ongoing settlement discussions. You may go back to the mediator. It's quite flexible. Or you may mediate and identify the significant issues that separate the parties, and you may get those resolved when you attend before a judge on a pretrial conference. So there's any number of ways that you can explore resolution of the claim, nothing really specific except to continue to follow up in the discussions that you have with the other side to see if you can resolve the issues. I think the important thing to recognize for all of the parties is that litigation is uncertain. The courtroom is a very uncertain place to be. You never know which way a case is going to go. I don't care how good your experts are. You don't know which way it's going to go. So there's always risk associated with entering the courtroom and rolling the dice there. It is a bit of a gamble.
Well, I can see that. And my question, before we get to the courtroom, is in that pre-trial conference where a judge is tasked with determining on two completely opposing opinions or sets of opposing opinions the potential outcome in the case. In your experience, what criteria will they use to decide who's right? At
a pretrial conference, the judge makes no decision about who is right, but rather discusses the issues, raises the issues, may offer an opinion on how things might play out in the courtroom, but has no power to compel the parties to concede anything at a pretrial. That doesn't mean pretrials aren't useful. They are quite useful. What happens before you get to a pretrial is that each party will prepare a brief for the judge. That brief will set out the party's position in briefly as they can. These cases are extremely complicated, so that sometimes is difficult. But before you get to the pretrial conference, the judge will have read a summary of what your case is all about, will have read some of the important documentation in your case on the plaintiff's side. The defense does likewise, submits a brief to the judge, and a good pretrial judge will have read all of that material, will understand the issues, and then at the pretrial conference, for each party, we'll talk about the upside and the downside of their case, the risks that they face, the strong points and the weaknesses of their case, and try to get the parties to understand their weaknesses on both sides, the plaintiff to understand their weaknesses, the defense to understand theirs, and look to encourage or coax the parties to a resolution of those things. But in the end, at a pretrial conference, if the parties aren't prepared to settle, the pretrial judge has no power to make the parties settle, no power to resolve any issue. But we have to take what a judge says quite seriously. After all, they're impartial. They're concerned with justice. It would be folly for any party to ignore what a pretrial judge had to say. And we do take our clients, or the CMP isn't at pretrials usually, but our clients are present at pretrials. And we encourage our clients usually to seriously consider what a judge has had to say in determining whether or not they wish to settle the case or not. But the only entity that has any power to force a result on the defense and the plaintiff is a trier of fact. So that's either a judge at trial, or some of these cases are actually tried in front of juries, 6 jurors. That will finally determine the issue or the issues between the parties subject to appeals.
And what's that conversation like after, like a mediation or a pretrial meeting? What's that conversation like between you and a defense lawyer when you're trying to determine, or is it between you and your client? Who do you talk to, and how does it go to, where the decision is made to either settle this case or to go forward with a trial?
The defense will make a proposal, or you'll make a proposal to the defense. The defense will may be prepared to recommend that proposal. So as between the lawyers, they may come to a figure for settlement that each is prepared to recommend to their clients. But ultimately, the final decision on settlement is the client's decision. Lawyers have no power to settle cases. It's the client that has the power to settle a case. The lawyer prepares for these negotiations, talks to the opposing lawyer, and as between the two lawyers may come to some understanding about the range of damages, and there's no precise number. It's always a range. It's from this number to that number, or something in between. If the lawyers can come to some understanding about what the appropriate range is, and then say that they are prepared to recommend to their clients settlement within that range, is then up to the lawyers to go back to their clients and seek their clients' instructions. So if the number is $10, I may go to my client and say, look, I believe your case might reasonably assess at $10. Are you prepared to give me instructions to settle at that? And the client has to make that decision. I will present the client with all of the pros and cons of a settlement at that level. Here are the risks going forward. Here are the plus side. This is the plus side of your case. And I will make a recommendation. It is my recommendation either that you don't settle for that or that you do. And if my client has faith in me as a lawyer, which hopefully they do, I have an expectation that my client will accept my recommendation. And that happens almost all the time, not all the time, but almost all the time, because that's my relationship with my client. They're paying me for my advice. I have much more experience in the courtroom than they do. I have a good appreciation for the issues, and hopefully when I make a recommendation to my client, they accept that recommendation. But they don't have to.
And if they don't?
Then we proceed to trial.
Okay, well, let's talk about that. So settlement discussions have failed. Mediation has failed. The pretrial conference hasn't reached an agreement or whatever has happened. Let's talk about going to trial and how that goes.
Trials are unpredictable, as I said earlier. The problem with trials in medical malpractice cases, unlike other kinds of cases, is that it's generally all or nothing. So if you prove a breach of the standard of care and causation, you get all of your damages. If you fail to prove any of it, you get zero. And that's the risk, and that's an enormous risk. So prior to trial, if there's a significant amount of money on the table and the patient declines to accept that money, they have to understand that they're either going to do well, get all their damages, or they're going to get zero, and there is nothing in between. And that's a risky thing for a lot of people, depending on what's on the table and the nature of their case. The other problem with trials is that sometimes it depends on who the judge is or who the jury is. You don't know whether they're going to be sympathetic or not. Often it depends on how the witnesses do in the stand. Quite frankly, a lot of people have difficulty testifying in a trial. It's a very stressful scenario. They get tested by vigorous cross-examination. It's quite traumatic, actually. Trials in medical malpractice cases take a long time. 3 weeks, 4 weeks, 6 weeks, 10 weeks of trial every day in the courtroom. Extremely expensive cases to try. So you don't want to go into the courtroom unless you're pretty confident that you're going to win the case. Otherwise, it's a dangerous place to be.
I can only imagine that for either a judge or a jury, knowing what we both know about how complicated medical malpractice cases can be, the science, the issues, the research, that it must be tough to translate the information clearly to a judge or a jury in a way that they could truly make an informed decision. Any comments about that?
It's very difficult. Many of these cases are extremely complex. I've had cases where my own experts have told me that they didn't understand the case, and therefore that no judge and no jury is going to understand it because of the highly technical nature of the case. And I think it's a feature that isn't necessarily unique to medical malpractice cases, but is common to medical malpractice cases, in that these cases are extremely complex, and the medicine can become extremely complex. The terminology is difficult. We often give a glossary of definitions to the judge and the jury, but how do they follow it? Lawyers have a terrible time explaining this.
Who decides if it's a judge or a jury case?
Either party can select a jury. So at the pleading stage, when you start your claim, the plaintiff can elect a jury or the defense can elect a jury. There have been cases, it doesn't happen that often, where the judge may dismiss the jury on motion by one side or the other because the case is too complex for a jury. But there's a tendency to preserve the jury process and to keep juries even in medical malpractice cases. So that would be a tough thing to do. But it's a huge challenge to distill these complex medical issues into terms that can be understood by people who have no medical background. And we rely very heavily on our experts to do this. And I'm sure we'll get to talk about the skill of our experts at some point. We rely on demonstrative evidence charts and diagrams and that sort of thing to help illustrate these difficult medical concepts. But in the end, you really don't know if you can distill these things down to understandable bites for somebody without any background in medicine. It's a very, very challenging thing.
I can speak to that from my own experience. The first time that I was in a trial, maybe the second time I was there as an expert in a trial, we had a giant fetal monitor tracing that had been blown up 100 times real. And I spent the first 2.5 hours on the stand trying to teach the judge how to read a fetal monitor tracing, information that I'd spent a lifetime learning. And I remember, being grateful for the opportunity so that what I was about to talk about was hopefully understood, but also being really conflicted at the same time, saying, I can't teach you what you need to know in 2.5 hours. I simply can't. It's impossible to know what you need to know. So it's got to be challenging for everyone. I can't even imagine a jury trying to make a decision of what was right or wrong based on science, of what we've had to know.
I think that's a great example of the challenge that we face. Take tracings. We know the challenge in interpreting tracings as it is. And I've devoted a lot of thought to how would I tell a judge or jury to interpret the tracing. And we have to take it in very small bites. Right. We have to say, we'll give a single slide or a diagram and say, here's a late deceleration. This is what it looks like. And then you have to identify where it occurs. So you have to think about how you would be learning these things from a blank slate. And that's how you've got to introduce it to the jury. But it's very challenging because, as we know, in a lot of these cases, there's a lot of controversy over the interpretation of the tracing by the experts in the case, never mind the trier of fact.
Sure, absolutely. So let's say you go to trial and you're successful. And it's celebratory, and from your perspective, that's a win. Of course, from the defense perspective, that's a loss. But is that the end of the case, or how often are these judge or jury decisions appealed and go on to higher courts?
Appeals in medical malpractice cases, I think, are pretty common. So you can, if you're not dissatisfied with the outcome, you can appeal. Appeals are challenging. It's not, the onus is on the party appealing to demonstrate the merits of the appeal, and it's a very high threshold, a very high bar to demonstrate enough evidence to upset certainly a jury, but even a judge. So appeals are very problematic and they're expensive. They probably fail more than they succeed. But you do have a right to appeal if you wish, and that certainly adds a considerable expense to the party who's already devoted huge time and resources to a trial.
And is the appeal just like another trial, run all over again?
No.
Experts?
There is no evidence called on an appeal. An appeal is heard generally by 3 judges of the Court of Appeal, and they rely entirely on the transcript of evidence from the trial without hearing evidence from any witnesses.
That's interesting. And how that must just tie up the process, because I guess my next question is, let's say you take a case to trial and you're successful. The plaintiff's lawyer, the plaintiff is successful. And let's say, for instance, they're awarded that $10 that you talked about earlier. How quickly would the patient or plaintiff actually see that money in their pocket?
Generally, I try to sue for more than $10. I try not to try these cases for $10. But in my cases that are more than $10, can you believe it?
No, hardly.
Yeah. But in the cases worth more than $10, certainly the defense in medical malpractice cases are very prompt in paying. So they will see the money very quickly once.
Like a week or a month or a year? Or
No, certainly within a month.
Within a month?
And sometimes within a week.
Really?
They're very prompt in paying once the matter is finally resolved. They're very prompt.
Talk to me for just a minute about what that's like for you and what that's like for your client. A win. Win in a courtroom.
Well, for me, it's rewarding, but for my client, it's a massive relief. Getting judgment and having the money that they need to get a break from 24 hours of service to their loved one in these significant birth trauma cases is life-altering for the patient, for the client. It's life-altering. They've devoted 6 years or so to 24-hour-a-day, round-the-clock care for their child, and they finally get enough money to take a break. And it really is life-altering. My own view is that when those kinds of losses can be attributed to somebody else's fault, it's only appropriate that the person who causes the loss ensure that the person who suffered the loss is compensated. And when they get compensated, it allows them not to be restored to where they were. That's impossible. The person remains disabled. But to get some relief and some sense of security that after the parents are gone, the disabled child will be continued to be looked after for the entirety of their life. Parents need that reassurance that after either I'm no longer able to provide the care that I need to provide to my child, even as an adult, when the child's an adult, or after I'm gone, that my child will still have the resources there to lead a reasonable life, to have the care that they need to be safe and sound and secure. And that's a huge, huge relief for these parents.
I could only imagine. All right, well, thank you very much once again, Richard. In our next discussion, I think we'll talk about what you alluded to a few minutes ago about working with experts. I know for the healthcare audience, doctors and nurses who've ever wondered or considered being an expert in medical malpractice lawsuits, this will be of great interest to them and to everyone else. So thank you.
Thanks, Chris.